Yes, Arnold? Hello, Arnold?
Good morning, Mr. Omar.
Yes, morning. How are you?
I'm fine, thank you. You are in which case number?
E121 of 2021 and E120.
Yeah, I can see. Okay, thank you. Thank you, Mr. Omar.
What are the directions? When are we starting?
Exactly at 9.
Exactly at 9.
Yes, Mr. Omar.
Very well. We are ready and set.
Okay, thank you. Okay, thank you. Morning, morning.
Morning, my lady. Morning, my lady. Let us use that one.
The other members of the court, my name is Nyamodi, and I appear together with my learned friend, Mr. Ogoso, for the applicant in E120 of 2021.
Yes. And who is appearing for the respondents, please?
My lady, if it pleases you and if it pleases the court, my name.
Please, my lady and my lord, in E120 of 2021, my name is Ongoya. I appear for the first respondent.
First respondent.
My lady, my name is Umanza Ogati. Umanza Ogati. I appear together with Mr. Matuku.
In that matter, for the fourth respondent, my names are Danstan Umari. I do appear together with Mr. Shadrach Wamboi, Mr. Paul Macharia, Miss Anita Masaki, Miss Liti Kathurima, and Mr. Omayo Aranga for the fourth respondent. Both of them are present. Appear for Ocharo member, who is the fourth respondent.
Okay, yes. And by way of control, yeah, I'm ready, please, my lady. We appear for the sixth respondent by the name Professor Oli Mugenda. And we are through. Now we come to 1 and 1. Let us repeat the exercise.
I think for the third, Mr. Omwansa is representing the second and the third.
Yeah, fourth respondent.
For the fourth respondent, my names are Dunstan Omari, together with Shadrach Wamboi, Paul Macharia, MS Anita Masaki, MS Liti Kathurima, and Mr. Omayo Aranga for the fourth respondent, Ocharo member.
Omayo who? Omayo Aranga.
Omayo Aranga. He's present, my lords and lady.
We move to one.
Yeah, please, my lady. Mr. Benson Mushiri and Franklin Beck.
In 121 for the sixth respondent, the Honorable the Attorney General, I am Nyamodi, and I appear together with my learned colleague, Mr. Ogoso.
Yes, we have the filing and the time for the filing. And we still have papers streaming in. The next is the issue of prepared, and we follow the same pattern. We start off with 120.
We have managed this morning to put in a replying affidavit of Tonsin Nafula. We have also put in written submissions, and we have put in our digest of authorities. We have served all our colleagues by tool of one group mail, and we are ready to proceed. I must apologize that our filings are not very elegant. I must take that responsibility from the very outset, but we are ready to proceed.
Myself and Mr. Ogoso are ready to proceed with 120.
So 120 and 121 as well.
Yes,
But
it
we
is.
don't. Yes, so Mr. Ungoya also ready to go.
Yes, my lady.
We go down the line for the second respondent.
Respondent, we have filed our replying affidavit, case digest, and our submissions in A121 and E120. We are equally ready to proceed. May I also bring to the attention of the court that the fourth respondent filed a preliminary objection dated the 24th of April 2021. On our part, we are ready to proceed as the court will give directions on how we proceed.
Yes, Dane?
May I please, my lady?
Presiding Judge, sorry.
Yes.
Go ahead, Judge, you can say.
The lawyers here should just get off screen for 15 minutes and then come back.
Okay, sir. Agreed, Judge?
Actually, I was going to suggest my colleagues in these particular matters we've dealt with can simply mute themselves as we deal with the other matters. Then we just, from there, we move on seamlessly to this matter. We come back to it.
Okay, sir. So, technical team, into our report so that we can proceed.
To our PO,
Yes. Yes, please.
My lady, PO has never been dealt the way counsel intends to deal with it. It will always remain a PO, and it will be dealt with as a PO. Our suggestion is that the court allows the PO to be determined. The net effect of the PO being successful. My lady, my lord, there will be nothing to be determined. We are requesting the PO to be determined first before the applicants proceed with their matter. We will only take 5 minutes. They respond on the question of law. And we are asking the question of jurisdiction. That's all, my lady.
Your Ladyship, I remember
That this court does not have jurisdiction to entertain a 5.2b application?
My lord, what we are saying, the applicant in E120 was only enjoined as an interested party. Does he have locus to file an appeal or a stay? Yes, my lord. Yes, my lord.
Even if you were to succeed on that one, there are still other parties. There's still another party who has before us a 5.2b. We will still have to deal with the 5.2b one way or the other. So why waste our time dealing with that, which in the end will be purely academic? We will still have to deal with the 5.2b before us.
My lord, my suggestion then is, let us deal with application E121, which is validly before you. We set aside that one that is contentious, so that we deal with, because the prayers are the same, the arguments are the same, but the question raised by the 4th respondent is valid. Why don't they withdraw and argue their matters in E121?
Judge, we can do it this way. They are interrelated. The PO, we have the PO, a brief representation on the PO, back to back. Then we shall do two. Are you in agreement, judges?
Presiding Judge,
Yes.
120. That is the basis of our being empaneled today, to hear the 5.2b. Mr. Omari can tell us when he is responding to this, he'll say, in one, there's a proper one before you, in the other one, there isn't, just strike it out. So when we finally come to make our decision, if we are convinced there's no jurisdiction with regard, or there's no locus with regard to the one matter, we'll strike it out and make a ruling substantively on the other one, which is not contested in terms of being before us. That we will save time.
I take the directions, we can proceed that way.
Okay, sound.
Thank you, Mr. Omari.
Much obliged, my lord.
Yes.
Allocation, you have only dealt with the applicants, so that we also organize ourselves on how we will respond, the time allocation.
Yeah, equality of arms. Equality of arms will require that we give both parties the same amount of time. They have taken 30 minutes. If there will be any need, then we shall see how we can add them time. The first to address us is taking 15 minutes. The balance of 15 minutes will be shared between the other who are supporting, and then the respondents will also have 30 minutes. If there is any need to increase the time, we shall deal with that when that time reaches. But for
of our application, that memorandum of appeal, draft memorandum of appeal, sets out 7 grounds. But for purposes of this session, I would limit myself to just 2 or 3 grounds to demonstrate the arguability of the application that is currently before you. My lady and my lords, the learned judges of the Superior Court
in rendering their ruling on whether or not
Kwamboi, I will do 4 minutes. He'll do 3.5 for the PO. But I know the good lords and lady will accord the young man 1 extra or 2 extra minutes. My lady, among the conditions required for a case for the courts to give conservatory orders is whether the subject matter will be rendered nugatory. My lady and lords, immediately the orders, conservatory orders are granted, that were granted are vacated. Already, the interviews for the Chief Justice are complete. The JSC will sit and present the name. Parliament will sit the next day, and the name will be forwarded to the President. And once that candidate is appointed, Article 168 comes to play. The courts cannot remove that Chief Justice unless somebody files a petition to the same JSC and the process of Article 168 takes place. My lady and my lords, you are being told that if you do that, then the matter before the High Court becomes moot and academic. Number 2, my lords, my lady, Mr. Mwansa has told my lady and my lords that the famous or infamous post-election violence in this country of 2007 was because there was no trust. Kenyans did not trust the court then. They went to litigate on the streets, and thousands of Kenyans died because the process was put to question. My lords, out of curiosity, none of the political players has mentioned anything about what is going on. Save this country, we do not have a repeat, because 2022 is more explosive than what it was in 2007. Third, my lords and my lady, my learned senior has raised the question that the DCJ can act only for 60 days, for 6 months. And we are likely to face a serious constitutional crisis. My lady and my lord, I'll urge the court to take judicial notice that when Governor Sonko was impeached, the court froze the time from 90 days for the elections to be conducted to date. That provision is frozen. We'll be urging the court that already the courts have pronounced themselves. Therefore, the timelines cannot be the reason to plunge this country into a serious, more difficult situation if the integrity of the interviews is not dealt with. Lastly, my lady and my lords, the applicants have said that why did we take all this time to come to court? That the petitioners are indolent. My lady and my lords, the allegations and the issues of contravening the law and the constitution started when the interviews were starting. And therefore, on the 12th of April, that is when these issues came to the public limelight. The petitioner, fourth petitioner, didn't know that none of the contestants was unresponsive. They never filed their wealth declaration forms. This is information that came to us on the 12th. We didn't know who is going to chair the panel. This is information that came on the 12th and reinforced by the media. And therefore, the petitioners rushed to court to remedy the situation. My Lord, because of time constraint, and I totally appreciate and agree with the sentiments of my learned senior Ongoya and Omwansa, may Shadrach deal with the question of the preliminary objection.
My lords, my name is Shadrach Wamboi, my lord, and I will argue, my lord, with regards to a preliminary objection that was raised by the fourth respondent, dated the 24th day of April 2021. My lord, at the outset, I note that the PO is in opposition to the application number E120 of 2021, my lord, the application filed by the Honorable the Attorney General, my lord. My lords, flowing, my lord, from the proceedings before the High Court, which have been annexed by the affidavit by Tolfin Nafula, my lord, the court will note at page 19, my lord, that the Office of the Attorney General was enjoined to the proceedings before court as an interested party on the 21st day of April 2021. My lord, the legal regime we are in today allows a party to be enjoined as an interested party by virtue of Rule 2 and 7 of the Mutunga Rules 2013, my lord. My lord, knowing too well, my lord and my lady, that the jurisdiction of this honorable court flows from the Constitution and the statutes that we have, my lord. My lord, I will make reference to Article 163(7) of the Constitution, my lord, which, my lord, decrees the decisions from the Supreme Court.
Mr. Wamboi, please help me. Do we have a provision in the Court of Appeal rules for interested parties?
Indeed, my lord, there is.
Which one?
My lord, I will not really at this point of time make reference to it to limit myself to the proceedings before the High Court.
An important question because we don't have the position of interested party in the Court of Appeal rules, and today the application number E120, there is a substantive party called the Attorney General.
Indeed, my lord.
Yes.
My lord, the Attorney General, my lord, was initially an interested party in the lower court proceedings and has since come to this court, my lord, substantively as a party seeking stay or making an application under Article or Rule 52B of the court, the appellate court rules, my lord. And therefore, my lord, the Supreme Court has had the occasion of giving the parameters in law through which an interested party can participate in proceedings before a court. My lord, to the extent that the controversy is between the substantive parties, Judicial Service Commission and Professor Olive Mugenda, my lord, we find it improper for the Attorney General to have come to this honorable court and to have made the application that is before court right now, my lord. My lord, we have annexed...
Is it your position, counsel? Is it your position,
yes, my lord,
that an interested party who is aggrieved that your position?
My lord, I am sorry, we lost a little bit of the connection.
Yes, I will. I'm asking you whether it is your position that an interested party at the High Court, a proper interested party at the High Court, who is aggrieved by an order made by that court, cannot, as of right, approach this court. Is that your position?
Indeed, my lord, that is the position we take, my lord. To the extent, my lord, that the interested party can only raise their concern through the substantive parties in the proceedings.
Listen to me carefully. I do not mean in terms of what they can do where they are interested parties, but where they are aggrieved by an order in that place where they are interested parties, do they or do they not have a right to come to this court in their own capacity?
My lord, as far as the Fugisha case is concerned, as it was ruled in the Supreme Court, the interested party can only find their way to this court through the substantive parties below, before the High Court, or the courts below, my lord.
Okay. All right.
Yes, my lord. We have made reference to the cases, my lord, and there has been a preponderance of cases on this issue. We have highlighted them in our case digest, and I urge the court to dismiss in its entirety the application by the Honorable Attorney General. That is all from me, my lord. Thank you.
My lady, just with your kind permission, this one, just on the issue of the interested party. My lady, this that.
Wait, we are waiting, Tomanza. I think we are through with you. Because we moved from you, we went to Omar.